Okay. Thank you very much for attending this very interesting lecture, which is co-funded by an EUPLANT project from the European Union. So we are very honored to have Professor Guobin from Tsinghua to deliver this very interesting talk about limited exclusive rights for big data. So Professor Guobin is actually very famous among Chinese scholars, and everyone actually studies Chinese IP law will have a clue of who he is. Right? He writes extensively in this field, and he's now the director of Tsinghua IP Center. Right? So let's give a warm applause to Guobin, and let's welcome his talk. Thank you.
Okay, thank you, Professor He, for your invitation and also for your introduction. I feel pleasure. It's also my great pleasure to be here again and give today's lecture. The topic is on big data. I just published an article in a Chinese law journal arguing for some kind of limit protection for big data. Here, I use the technical term big data, but it has no clear legal definition. Basically means a connection of a huge amount of data. You will compare the term with the database used by the EU directive. I think the EU directive legislation probably turned out not a big success. It's very controversial. A lot of people believe that kind of legislation does not help development of data industry in Europe at all. They create a pretty broad exclusive rights for the connector. For example, you must prevent under the directive the connector of the data could stop others from utilization, including from copying, distribution, or broadcasting or something. The content of the database is very close to they call them sui generis rights, very close to copyright protection. And I think that's too broad, but I know they use a database means a structured kind of data. And they don't have a very clear requirement for the size or the volume of the data. I think that's a big problem because if you don't put a clear limitation on the requirement for the size, that could cause harm to the public policy support or maintained by copyright. Here, I require the data. The data must be very big, however you call them big data or big data set. So why the size is very important? Of course, we will talk later. Under copyright law, there's a public policy. We need to put some kind of raw material or this kind of data as a kind of building blocks in the public domain to make sure the public has the freedom to utilize this kind of data to create derivative works or other types of work protectable under the copyright law. If you don't have this kind of threshold requirement, that means everyone copy a small amount of data could violate this kind of new law. That will cause a direct conflict of the copyright law's policy. But when you emphasize require the amount must be very big or the substantial volume, and then you can avoid this kind of conflict. I think that's very interesting. Probably it's one of my contributions to this kind of talk I'll talk later. So here we basically use the technical data, which means a huge amount of data, but we don't require the data set must have to be structured. I think that's the EU law requires the database must be structured. I think now the search engine technology is very well developed. When you use that data, you don't rely on the connectors structure, so you could find it easily through a search engine. So you don't know now. There's no need to emphasize the structure of a database at all. So here, just a connection of data. We don't care about the structure. In China, I think also in this world, a lot of debate about how to protect this. A lot of people treat the big data as a completely new issue, and you read a lot of articles, including English literature. They frame the data as the newly found raw materials for the data industry. So they frame this kind of issue as a completely new one, but actually it's not. I think the existing IP law already cover most part of this kind of issues. So that to understand is very important. Otherwise, you will simply ignore the whole bunch of IP law and then propose to create a completely new set of profile-like system. I think that's completely wrong, and then you cause a lot of problem how to reconcile the new legislation and the existing IP law. So that's very important first to understand the background in this area and to understand where's real the legal gap. I think for me, I think the gap is very, very narrow. Only a brief and a small part of this kind of area has never been covered by existing law. And then we could fix this kind of small problem rather than ignore the whole system, treat the data protection issue as a completely new one, and then try to come up with a very ambitious proposal. That's completely wrong. So first, I will talk about the existing legal regime or system protecting the big data. But first, I think very important, the trade secrets law. In China, we don't have a separate legislation. We put it under the framework of anti-unfair competition law. But even we put it under the competition law, I think lots of people, scholars, including the Chinese Supreme Court, view trade secrets as a kind of property interest or property rights. It's very controversial, right? Someone believes the trade secrets not a subject matter of property rights. It's kind of only a protection and probably very close to a contract relationship, right? If I sign a confidential agreement with the party, then I own some duty to that. It's not a kind of typical property-like protection. And that's now it's not a mainstream point of view viewpoint. I think the mainstream scholar treated the trade secret protection as a property-like protection. Although the protection very narrow, it's not like a complete dominance or control over the information. For example, if you own some trade secrets, you still could not stop others from getting the same trade secrets on their own, right? For example, you invent the same formula without interfering with your trade secrets. So it's not a completely control of the subject matter. And that doesn't matter, it's still treated as a kind of property-like protection. But in China, we don't have separate law, so we put it under the anti-unfair competition law. That does not matter. So the first one is the trade secrets protection. The second is, I'll talk later, what's the condition for this kind of protection. The second one is this kind of connection of data maybe protect as copyright law works and copyright law. That's a very important. First, many of the contents of the data itself, we call them data entries, copyrightable. For example, if a website like Yelp, YouTube connect a lot of video or users reviews posted on the website. This kind of user reviews, for if you go to a restaurant and take several pictures and then make some comments on the special dishes and then put on the website. This kind of, we call them data entries. This kind of data entry itself, themselves, is copyrightable. Of course, this kind of rights owned by the users or the consumers, user of the website, not the website itself, not the Yelp or YouTube. But it still helps. For example, if you wish, the website could use the copyright tool to protect its interests. How? Just sign a contract with the users, right, or the creators, requesting the user to grant back the copyright to the website, and then the website could use the granted copyrights to sue the competitors. And in China, we do see several websites or this kind of internet companies applying to this kind of technology strategy. For example, Sina.com, Sina Weibo, I think the Facebook-like website in China. Actually, in the past, they have an IP policy require all the users to transfer the exclusive rights license, grant an exclusive license to Sina.com, and then Sina.com use the exclusive license to sue competitors like 今日头条, who copy a lot of famous user of the celebrities posts in Sina.com. Of course, you are a newcomer. You want to make your own website more attractive, right? But that's there are no enough this kind of celebrity posts, so it's hard for you to attract the common users. So how do? You will the celebrities say, how about transfer all your posts? You post on the Sina.com in the past, now move to my website and make it available to the public. So we transfer most of the posts of the celebrities to the new website and compete directly with Weibo and Facebook alike company to obtain this kind of advantage over the first comer. So and then the Sina will rely on the copyright to sue the newcomer. The problem is whether this kind of contract terms are requiring the transfer of or granting of exclusive license is enforceable or not. I think it's not very clear. Some courts say yes, this kind of right is enforceable. Or you say click on contract, right? If you in China already agree this kind of format in concluding a contract, so this should be enforceable. Someone say it's against the public policy because you actually don't allow the user to have a free choice, right? They want, because Weibo.com like Facebook probably enjoy some kind of leading or dominant power in Chinese market. So if you require all the consumer to sign agreement, they have no choice. So it's like a standard contract. Whether it's enforceable or not, it's a big problematic if you cherish the public policy and the copyright law say we should not allow a dominant player easily deprive of users this kind of important interest. For example, you create a very innovative or creative video and then you post on the Weibo.com and then you lose on the control. I think that's probably not fair. So some courts say this kind of contract is not enforceable. But I'm pretty sure if you really negotiate with every user in person, right, get this kind of granting of exclusive license, probably is still enforceable. But if you just put it on, you already have a dominant market position and use a standard term, probably it's not enforceable. I think first, some content of the big data is copyrightable, so the connector could rely on this kind of legal tool to protect the interests against the competitors. But the tool is not very good because for Sina.com or like Yelp or Facebook or YouTube, actually they are not that interested in inclusive license. I think that's the only one to exclude competitor from copy the whole bunch of the data, right? They don't care about whether they really have the exclusive right over the specific entries or the content of the post by the users. So this kind of copyright tools does not fit the purpose very well, right? They get too much. That means they increase their cost, right? Because you only want to stop the competitors, but now you have negotiated for exclusive license for every entries of the data. That means if you heavily rely on this tool, they will increase your own cost. So it's not a proper one. The better one, I think, probably is, as I will propose that create a general, very narrow exclusive right for Sina.com. Once you connect enough this kind of data, and then you will naturally, automatically get an overall control of the bunch of data. You don't need to get a license from every individuals. So you could rely on this kind of very narrow exclusive rights to stop the competitor from copy the whole or substantial part of the data. So that's much more efficient. You don't need to negotiate for this kind of exclusive rights at all in the future. So the second one, copyright protection is important and not that fit into the purpose very well. Another I think tool is if you have arranged the data in a very innovative or creative way I think that probably we use big data, the connection of the big data as a derivative work. But most of the time, I think the help of this kind of tool is very limited. Because as I just mentioned, like Facebook, YouTube, or Google Map, Apple Map, they don't edit or rearrange the data in a very innovative way. They just create a website and framework, and then the users post the data, right? They automatically store in the internet servers. So it's hard to say this kind of connection or efforts is a kind of innovative one, creative one. They does not generate originality for the connection. So I think that to protect the big data as a whole, as a copyrightable data, sometimes it works, but in most of the time, it does not satisfy the need of the connection. The second the types of protection. The third type is anti-copy protection by general principles of computational. When it is difficult for you to get the protection under the trade secret law or the copyright law, it's still possible. Under Chinese law, we say you could get a kind of anti-copying protection. For the Article 2 of the anti-competition law say everyone, when you're doing business, you need to follow so-called the good business ethics. It's very general, right? So the many courts say that good ethics means no copying of your competitors' important asset, including this kind of big data. But sometimes in many areas, I think the practice is to copy everything in the public domain. Right? Sometimes it's hard to say whether there is really a customary rule stopping or preventing them from copying data in public domain. Right? But so far, Chinese court believes so. So we apply the courts apply Article 2 to resolve quite a lot of this kind of dispute. I think that it's already become almost a common practice in China now. And they also have problems because the article is very general, right? Simply tell you good moral or good ethics, and then we don't know what's the scope of the protection. For example, how much data I need to copy when you determine there's a violation, right? The good moral does not tell you, right? And what kind of behavior, for example, I copy it is a violation, or copy is fine, but I redistribute it, it's a violation. So the law does not tell you what kind of protection we should have. So that's why we think that this kind of Article 2 is not satisfying. We need to come up with a new regime to provide more certainty, and let the public know the boundary of the rights, and it help to protect the incentive of investment. So the third one. The first one is sometimes relevant related to copyright law, sometimes not. We can talk about technological measures. Under the copyright law, and most countries' copyright law probably the same. If the data itself is copyrightable work, for example, a lot of users reviews or comments on the restaurant dishes or on a hotel room service, something like that. This kind of small pieces of data usually is original enough, right? According to Chinese court standards, sometimes you only need for a literal text, only need 7 Chinese characters. That's enough to be viewed as a copyright work. So if a consumer wrote a comments or review usually more than 50 or 100 words, right? So this kind of entries or these comments itself is a copyright one. And then if you connect a lot of this kind of copyright work together, and then apply some technological measures to restrict the public access to this kind of content, and then if we think this kind of technological measure is effective, and then this kind of technological measure itself, not the content, is protected by the technological measure. The technological measure itself will be protected under the copyright law. Anyone circumvent this technology or provide the tools to circumvent this technology will be viewed as a kind of violation of the copyright law. So it looks like the technological measure itself already become a new subject matter of property-like protection. So this kind of measure very important. In practice, a lot of connector of this kind of data actually apply the technology to protect it. So even it could not protect the content itself under the copyright law, but if you apply measures to this kind of data set, the measure itself will be protected. And it also cause some kind of theoretical issues first, because the protected content is not from the owner of the technological measure, right? The content from the third party. Whether when I all connect this kind of data, the data could be a copyright work, also could be a personal data, right? The consumers submit a lot of personal data. Whether this kind of measures protecting third parties' copyrightable works should be viewed as a technological measure protectable under copyright law. Maybe it's an issue, right? Or we will never see a court in China adjudicate the issue like this. The second one, sometimes a very interesting issue. Most of the data is are not copyrightable. For example, a lot of consumers' personal information, telephone number, ID, or other behavioral data on internet, on online shopping, something like that. It's generated automatically by the computer system and then put it together. This kind of content is not copyrightable, but the connector knows the copyright law require the content must be copyrightable first, and then the copyright law will protect your technological measure. But here, the connection of the data is not copyrightable. How to deal with this kind of problem? I put strategically, deliberately, put some my content, right, copyrightable. For example, I put my copyright work mixed with this kind of huge amount of data, right, and then apply the technological measure to protect them. So, and it comes a new problem issue. If we use a technological measure to protect this kind of uncopyrightable data with a few of copyright work, deliberately put into by the connector, whether this kind of technological measure, because the third party want to circumvent this measure, and then you only get access to the uncopyrightable data, right? They are not interested in the small part of the copyright work you put into the whole data set. They only want to get the raw materials. And whether this kind of circumvention is also a violation against the copyright law, I think it's not very clear. That's I think the new problem posed by the big data practice. That's here. Just list all the kind of 4 types of existing mechanisms in protecting big data. Now I give you I put a note here. Actually, we are not writing on the blank slate. Actually, there's quite a lot of the existing regime could be used to protect this kind of data. If you want to propose a new legislation, that's very important to understand the existing one, right? And then you know where's the gap, and then fill the gap. That's the very important one. Now I'll talk very quickly about the several specific issues when applying this kind of the systems to protect big data. First one, trade secrets. We already know the trade secret require the secrecy, utility, and the confidentiality. You must take this kind of measure. I think that everyone probably knows this kind of basics. And here, in China, there's a dispute. Some people say, some scholars say, including some judges from IP court, for example, several judges from Shanghai IP court wrote an article say it's ridiculous to protect big data under the trade secret law. They say most of the time, it's actually not all the case. Sometimes, like the YouTube's one, they say all the users, they post the videos online, right? And then every entry of the video is accessible to the public, right? Like Baidu Map or Google Map. When you put all I think the map information on a restaurant, hotel, on the map, and then you make it accessible to the public. How can you say the connection of this data still could be protected as trade secrets? Say it's already available. So here, I think the problem is a lot of people believe if every entry of a small part of the data is available to the public, and then the connection of the data should not be protected by or viewed as a trade secret law, trade secret. For me, I think that's it's a misunderstanding of the trade secret law. Here, I show you the article 39 of the TRIPS. It simply say, well, what it means secrecy? Say the information is in secret, in the sense that it's not as a body or in precise configuration or assembly of its components. That means if the as a body or in precise configuration or assembly of the information or components is not generally known among the or readily accessible to the public, and then this kind of a body of information or the configuration of the exact assembly of this kind of information should still be treated as secret information. Here, for example, it's true if I put all the content or use a Google Map as an example, you put the location information or located information and also some of the other relevant. For some map even provide some consumers comments or reviews of the hotel or the restaurant in the map, and then you could access them all very easily. And then if a competitor download every entry of the content directly from the map, right? The map service available to the public. Well, this kind of connection itself is not a violation of the trade secrets law. Or you get every piece of information from public sources, right? From the Google Map website. But if you don't do this way, you find a secret API or other access directly connect to the Google's internet server and download the whole bunch of data altogether into your own server. And then if you violate for example, the technological measures in protecting this kind of data, this kind of whole bunch of data or the connection of data itself is still a kind of subject matter of trade secrets law. Of course, in public domain, this whole set of data is not easily available, right? If you want to get this kind of connection, you still need to use the web crawler to download from Google website, and then you deal with Google, take a lot of technical measures, right? For example, if you come from the web crawler from the same IP address, probably it will block you. Every day you could download very little, right? So it's not that easy for you to download all the content piece by piece and then put them together. So from the public source, it's very hard for you to get the connection of this data. But if you go to a secret channel, or we call them a secret API, to get the bunch of data all together, all of a sudden, and then you still kind of violation of a trade secret law. I think it's pretty common for in China. Personally, I participated in a debate of a semiconductor case, also about trade secret law. Someone say the defendant copied the blueprint of a semiconductor circuit design directly from the computer. I think that's very worth quite a lot of money. And then it was used by the plaintiff. And the defendant say that because you already sold the chip on the market, right? Everyone could buy the chip, and then through the kind of reward engineering, now it's pretty easy. He showed to the court. He hired seven engineers to do this kind of reverse engineering work, probably in 6 days or 2 weeks, and then they remove every piece of the cover and then get a copy of every layer of the design, put them together. It looks exactly like the blueprint they copied from the computer. They say because the design is available from the public source, so it's not protectable as trade secrets. Here the problem is, even you could get every piece of the content, put them together, but here in this case, you need to hire more than 6 engineers, right, to do this kind of work for more than 1 week or 2 weeks. This kind of substantial investment, right? That means, but you don't do, originally you don't do the copy this way, right? You simply download the content from my computer. So you have this kind of advantage over the owner of the trade secret. So in that case, we still treat the connection of the blueprint design in the computer itself is a kind of protectable trade secret. Here, the same theory, right? Even every part, every layer of the design available through the computer, that we put them together still costs you quite a lot of money or investment. And then trade secret, right, and you exactly want to protect that kind of investment. So even every piece is in the public domain, but the connection still costs you substantial investment. And then this kind of investment is worthy some kind of trade secrets protection. So here, the same thing. I think the trade secret law make it, the TRIPS make it very clear. So even small piece is available to the public. The connection still could be protected as a trade secret. Here, I think according to some research, if you are interested, you could read this one. I don't put the details of the pretty influential research report commissioned by the EU Commission. The title is a study on data sharing between companies in Europe. We talk about what's the legal barrier for all the private sectors to sharing the data of upsell. The conclusion is pretty simple. Say that they have a lot of barriers. First one, the entitlement or the ownership is not very clear because there's no clear law say about this. So the enterprise don't know what kind of rule to follow. I think that does not mean really the whole legal framework is not clear. Probably, I think a lot of enterprise does not know, right? Just like we'll talk later. Even China legislator does not know what the existing rules for this kind of protection. The second of the important barriers, they call them the secrecy measures, the confidential measures taken by all the connectors of the enterprise. What does that mean? That means actually the trade secret law works pretty efficiently, right? Effectively, because a lot of companies put the data in their server and take measures, and then they stop you from accessing, right? Other barriers, including, for example, the format or the data format is not standardized. So even a huge amount of data available, but you don't have the tool to read them, and that's another issue. A lot of researchers doing research on the standardization of data format. I think that's pretty interesting topic. Here, user reports show you the big barrier caused by trade secrets law for the enterprises to sharing the data. That means the trade secret law is probably still the most effective or important tools in protecting this kind of data. Even there's if you read the literature, a lot of scholars saying the trade secret law the protection is too strong and become a threat to public interests. For example, even the data is subject to trade secret protection. If the legislator or decision maker still could restrict the rights. For example, the EU law required the aviation industry, like Airbus, to disclose the information relevant to the safety of the aircrafts. So real-time disclosure to the government or the major business partners. Why they require that? Even they know this kind of a huge amount of data is a trade secret of Airbus, but they want to make sure the airplane is safe enough. So if you force them to disclose the public, and then everyone could become a check against the Airbus, right? A lot of people will watch the data very closely. So if there's any signal of problem, and then you could raise it to red flag to the government. So in this kind of scenario, that means even the data is protectable under trade secret law. If you wish, you still could apply restriction on the property rights. So that's the very important. And the second one is example. For example, in the United States, they also require a lot of pharmaceutical company to disclose the clinical data to the public, right? Even it's protectable and trade secret law. For public interest, it could be restricted. So I think that now in this area, a lot of people believe trade secrets protection for big data is too small, and they want to come up with some kind of measures. I think that's a lot of research on this. Another in China, a lot of interesting research on the financial data or the banking, the banks data on whether we should force for example, Alibaba, Taobao, or WeChat to share the data with the government or the regulators in this area. It's very interesting. Before the publishing of this article, a lot of people talk about who owns this kind of data. I think they don't have this kind of legal framework, and then they come out with a very complicated. For example, I love a commercial law professor come out and say we need to create a new law that authorize the banks to have this kind of property rights over this kind of data they connect, or they say some other scholars say the data should be owned by the users, not the bank. So that's a law. I think the conflicting views in this area. I think they don't have a clear legal framework how to deal with the connectors' interests and the users or even the regulatory interests. For me, I think it's pretty clear. We should have who invested, connect this kind of data, and then you enjoy some kind of property-like rights over this kind of data. This kind of protection, property-like protection, is a kind of negative right. You only have the right to exclude others from copying the substantial part of the rights. That does not mean you own any property rights over the specific entry of the data. For example, you connect a lot of meanings of users' personal data. That may be true. The user owns some rights over their personal data. It's still not clear, right? Different countries have different laws. China, whether the personal data is a kind of property or like subject matter for the user, not very clear. For me, I don't think that makes sense to treat the personal data as a property or like subject matter for users, because the value of a small piece of the personal data is very low, right? Under the traditional the property law theory, it's not worthy to create this kind of protection. Here we'll talk later. The demonstrates the classical article towards serial property. It's that only when the value of the property on subject matter increase, and then the society will tolerate the cost in creating this kind of property regime, right? The personal data, I think every piece of small data, it has some value, right? But that's probably not worthy worth creating a very complicated property-like system to commercialize or to transfer this kind of rights over the market. That does not matter. But I think probably the better approach is to treat the protection of privacy as a public law issue. So we rely on all government regulation. For example, we can regulate every user, connector of the personal data, and then heavily. It's a kind of a property regime, right? It's a kind of regulatory regime. I think we should work better. Actually, I think the Omri, the professor from Chicago Law, also published a very interesting book, What More Than You Know. They talk about the consumer protections. If you create a rights for every user, and then say every time you should get an informed consent from the user and to use the data, that's actually impossible. No real user care about the content and understand the content. So that system does not work. So how to protect consumer interests? His answer is pretty clear. In many areas, you don't rely on the consumer's informed consent or consumer owns choice. You rely on the government regulation. You create a uniform standard force everyone as a market to adopt this standard. That doesn't work like a property regime. It's definitely government regulation. Here, I think the same. Even you create a lot of rights for every user that will not result in problem in the future. We still will need to resort to regulation. Here, I just here want to talk about the relation between the connector of the big data and the owner of a small piece of information. Here's personal data is privacy right, something like that. And for YouTube, if you post a video online, right, this video may contain your copyright, right? Also contain the users maybe right in China, we can right to image or other things, or right to reputation, something. That does not will not affect the connector to the right over the set of data. So that's the interaction between connector and the specific owner. I think that's pretty clear. So it's also very important for every industry to understand this kind of legal framework. Otherwise, in China, very interesting. In fact, the commercial law professor has a complete view of ownership of big data, and then the civil law professor, another complete, pharmaceutical law professor also have their view of the data. They don't have this shared framework, and they all talk about the protection of big data. They don't share this kind of framework. It's hard to dialogue. So I think that's very important to educate all these kind of professors from different fields to apply the same framework, right? And then we know we are talking about what is the issue, right? If you don't have this kind of framework, you simply don't know how to interact with each other. It's very important. Here, I'll give you a real example to show you. If you don't understand what kind of mistake you can make, let's say Taobao was an unfair meeting. It's a very important influential big data cases in China. The content is pretty simple. The Taobao, because they have, everyone know, Alibaba, Taobao, they allow millions of sellers to sell goods through their platform. Right? They connect the transaction, real-time transaction every second, and then put them together into a database, and then they have a tool. I think the database or software tool to analyze the data and tell the user of this kind of data set what kind of tendency of selling the specific product. For example, if you are selling apples or cell phones online, if you become a licensee of this kind of software, and then you know what's the part, how many people bought this kind of cell phone or apples online, and in which area, and what could be the future tendency, right? This could be very helpful for you in the future to prepare enough goods, and then I think that's the become a core technology of Alibaba. Now they know everywhere. They put all this, they create a lot of local centers, Beijing, in Europe, in the United States, and then they know how many goods will be sold in the coming few days, and then you could prepare. Even before you get the orders from the consumer, you could prepare all the goods there waiting for the order. So once the consumer get send you the order, and then you could ship the order, the goods immediately to them just in a second. So that surprise a lot of consumers, like why do you know? A lot of companies say you must ship the products first from China to United States and then to their home. It's same logic, rely on this kind of technology. So most of the small business become a member or licensee of this kind of software, get access to this kind of database real-time information. It's very valuable. So I think Taobao also, get a lot of money from this, right? Not only from the license and the fee from the online sale. So very important. Here, the defendants is a member or licensee of this kind of data set, and then they abuse the access, the rights. They resell it to a lot other. For example, I get a license just for 1 year, for example, 10,000, and then I resell it to other small business, right? So you get the certain way the Alibaba's control over the access to the database. It's kind of typical, either as a kind of violation of contract term, right? Where the Taobao license is allowed to open these kind of terms, and then which restrict you to transfer the right on the access to a third party you violate. So that's kind of a contract law issue dispute. And the second one, I think in the contract, the Taobao actually operating making it right. Say it's a kind of trade secret. So licensed as a trade secret. So if there's a dispute, you definitely the third party or the defendants is violating the trade secret law, right? But unfortunately, this court does not believe this kind of information is a trade secret because they connect all the user, the seller's data. Most of data probably available online, right? You know, if you watch every seller with one by one, you could figure out how many cell phones he sold in the past, and then put them together. I guess the lawyers or the court believe it's not a trade secret. I talked with a judge, and then the judge. Personally, I don't talk directly with the judges from this case. I talk with a very influential judge from Jiangsu Court. She's a friend of the judge. I asked her why they don't treat it as a trade secret issue. He said simply said the lawyer does not raise this issue. So the court
lawyer what? Sorry?
does not raise the trade secrets issue. So they treat it as I think probably the lawyer don't believe it satisfies the standard of trade secrets law. So they frame it as a kind of unfair competitional issue. Say it's a connection of data. They cost a substantial investment. It's worthy kind of protection. It's a kind of fruit of labor. So, and then they resort to the Article 2 of unfair competition law. I should use the example to show a lot of people actually don't understand the system of trade secrets law. So they say the existing system does not provide enough protection. Actually, it's not, right? I think that's this case a typical trade secrets case. But if you really want to focus on the details, also this case involves a very interesting issue. Because if Taobao only license this kind of data to 1,000 users, maybe you still believe the data is still in secret, right? Because only 1,000 people get access to that. And here, Taobao licensed it out to, I think according to core statistics, are more than 20 million users, something like that. So but in every contract, Taobao require the users to keep all the information in secret, right? So do you think that's still be viewed as a kind of effective confidential measures, right? So I think that's pretty interesting. When I wrote my article, I reviewed some U.S. cases. Some court believe that even 100,000 people know the data, but if everyone has the confidential duty, and that means it still should in the private sector, right? It's not information in public domain. But some courts say if you disclose the information to too many people, and actually it's impossible to enforce all the contract restriction effectively. They probably have some doubt on whether this kind of confidential measure is effective enough. So I think that's here. I think if we don't have a clear rule and trade secret law, we don't say you license it out to more than 20 million, then you lose the secrecy. Probably not, right? So for me, I think that under the current law, it's still possible for you to treat it as a kind of trade secrecy issue. So that's use an example to show you the importance to understand the regime of trade secret law. But I think the big data really pose some challenge to trade secret law. You need to look at what it means secrecy, right? What it means, I just mentioned, if you got information from all the public sources, whether it's still enough to treat as a kind of secret information. The second issue is whether this kind of technological measure or contract terms. It's an effective confidential measure. Two elements, very important, and the trade secret law has already been challenged by the big data. Right? I think very interesting. In my paper, I don't focus on this issue. So here, I just use an example to show the importance to understand the trade secret law. And the second copyright law, we already talked quite a lot, so I just skip it. First, the data itself, the entries is copyrightable in most of the time, and if the connection or the rearrangement of the data set is original enough, you could as a whole, it's a kind of protectable work. We probably have work of combinations. In China, we do have a court say the connection of the data is not original, but the consumer comments, reviews itself, themselves are original. We do have a case, and that's something that the courts even support the connectors claim they already get this kind of license from the users. Or in this case, is pretty famous. 大众点评 versus Anban. It's also very famous big data case. Simply, 大众点评 is a company like Yelp. I don't know what's the
Open rights.
Okay. the users put a lot of comments on the website, and then the later comer the copy the consumer reviews and then get this kind of advantage, right? I think that most of the big data case in China follow the same, logic. The first one connect enough data, and the second one believe to connect the same amount of data to burdensome, and then simply copy the original one. That's the. Now they go to the anti-copying protection. I just show you the specific article I already mentioned at the beginning. This is Article 2. Business operator shall in its business activity follow the principle of voluntariness, quality, fairness, honesty, abide by law, and observe business ethics. And also, the second paragraph create a term saying, if you do something, the African made here, bringing up the lawful right and interest of business operators, and then you could violate Article 2. In China, I think the civil law country have a strong belief in very general principles. Here, the general principle of civil law, on the current general provisions of civil law of 2017, they also have a principle, we call them lawful interest principle. That means they say everyone's lawful interest will be protected by the law, but they don't define what it means a lawful interest. They actually give every court a blank check. If you believe some interest even has not been recognized by statute, but you believe it's worthy some kind of protection, you can label it as kind of lawful interest. So if the court don't want to apply Article 2 of unfair competition law, they could easily switch to the old law, the GPC, the general principle of civil law, the Article 5. I forgot the new law is Article 7 or something, the so-called lawful interest principle. You can label easily this kind of interest as a lawful one, and then the connector will enjoy proper-like protection very easily. Okay, now we'll move to the second part. We talk about several important cases that apply Article 2 of unfair competition law. Here, I think the court either apply Article 2, the good morals, or the article in the past, the old civil law, the mini civil code, Article 5 of the lawful interests. Different court prefer different articles. As a function are the same. The first one is the very famous but pretty old one, the Beijing Sunshine Data. Before that, in 1980s, we also have another case under the copyright law, the list of TV programs. It's not original, but the court say it's a fruit of labor. A list of CCTV's programs in the chronic or sequence. That's not a original work, right? As the course say, this kind of work deserve protection. Personally, I think that's the wrong decision, or the list is pretty short. And according to my theory, the investment is not substantial enough, so it's not. It does not deserve protection. The second, I think the requirement is the size or the volume of the data must be substantial, right? So this kind of the TV program list does not satisfy the two requirements. So it's not should not be protectable. And later on, I tell why we have this kind of two requirements. Here, in this case, the second of the first one is the TV program list case. The second one in 1997, the compilation of the real-time security transaction information defined like the Shenzhen stock market. You have the real-time transaction information, right? And then you transmit streaming to all your licensees, and then a third party without the permission. One of the licensee violates the contract terms, right? And streaming to the information to the third party, and then whether this kind of it also could be a contract dispute, right? If you have a term restricting the re-streaming or retransmitting the data to a third party, but that's a complicated contract issue. Whether this kind of restriction is violating the copyright law's policy, right? Because the subject matter is not protectable under the copyright law. Now, by imposing this kind of contract, you enforce this kind of contract just like a privately legislated copyright law, right? That's another issue. Here, the court saying this kind of connection of data is protectable, and the Article 2, that's the pretty famous one, the mainland Chinese law. And the third one is the Shanghai Han law. I already mentioned the Anbang one. That's the copy of the consumers' reviews of the restaurant or other shops. The court say Anbang has not contributed state or bear any cost, but has used technical measures to copy on the display the user reviews on its own website to acquire commercial benefit from this copy. So it's violated Article 2. But it's interesting that in all this kind of case, the court never tells you what's the limit of this kind of protection. For example, how many reviews you need to copy, right? Here, the requirement 700, or it's hard for the plaintiff to prove to the court how many data sets has been copied by the defendant. So if you want to apply Article 2 unfair competition law, probably you need to tell the public how much data, right, you need to copy. But most of the cases does not tell by you. That's why we think that Article 2 protection, unfair competition law protection, is not satisfied. We don't know what's the threshold, right? For example, if I just copy 1 or 2 entries of data, it could be risky, or we don't know, right? So we need a clear threshold for this kind of protection. The first one is, I think, pretty famous, the Baidu versus Tsinghua 360. It happened in 2012. It's, I think, also this case is a very famous antitrust case, the competition case. Tsinghua is Baidu is the leading search engine, right? I think probably is the second one in that time, probably Google, and now it's definitely the leading player in the Chinese market. And then the Tsinghua is a later comer. Of course, the Tsinghua has to do, I think, an investigation to figure out why a lot of users are reluctant to use Tsinghua. Because the user experience is very bad. For example, why you use Baidu? According to my personal experience, if you don't you start with a new computer, Apple's Mac system, don't know how to operate the computer. and then you just go to Baidu to post to search whether anyone has already posted a question on this issue, right? Most of the time, you need to check the self-assessment. Probably I get to finish in
You can.
20 minutes.
Yeah.
Okay. We will have more time to the debate. I go very quickly. In this case, the Jihu realized that's no enough users ask a question in its website. So that's very few answers, right? It's very hard for that commerce to attract enough users to post a question and post answers in their website. But the Baidu is a leading search engine. They already attract enough users, post questions there and get answers. So it's pretty easy for you to find answers for your questions. So as a newcomer, very hard to compete with Baidu. And then Qihoo find a solution. They copy directly all the question and answers from Baidu's server into Qihoo's server. So now, all of a sudden, you find all kind of questions could be found in Qihoo's website, and then you could improve the user experience. But here, all the content actually created by the public, right? Not Baidu. So Baidu does not have any kind of copyright over this kind of material. And then the issue whether this kind of copying should be allowed. And also at that time, the Qihoo raised this issue as a kind of antitrust issue. Say Baidu is a leading player. Baidu created the database called 知道 in Chinese 知道 and 贴吧 something like that. That's encourage a lot of people to post and content in the database. Say without access to this kind of database, that's impossible for my new search engine to compete directly with the Baidu search engine. So it's unfair competition. It's violating the antitrust law as a leading player. So you need to open the access to the competitor. At that time, the Chinese Internet Society organized a kind of mediation committee. I was a member of the panel, and they invited the CEO from both companies to explain why you needed this kind of protection, why you needed this kind of access. And then on, we realized it's too complicated. That's impossible for the society to come up with a solution. And then we leave it to the court. And at that time, very interesting. Actually, I tried to convince the other panelists is senior retired judges from Beijing court, something like that. Some of them support the defendants. They say, actually in China, a lot of people are not satisfied with Baidu's service, very bad. They put too much of this kind of advertisement on the search entries, so the current very bad. So we want to encourage someone to compete, right? Some judges say we need someone to compete directly or effectively with Baidu. So we should allow the newcomer to copy this kind of copyrightable content, right? And then could come effectively. They have this kind of, I think that kind of public policy concern. But for me, I think that's even the antitrust law is not a violation. Of course, the competitors, the leading one invest substantially, right? A lot of money to create this kind of data. And then newcomer want to kill me, right? I will still be forced to open this data to my competitor, allow them to kill me. I think that does not make sense, ridiculous, right? So this kind of a strategic resource should be reserved for the original competitors. So at that time, I tried to convince other panelists to accept my point of view on this kind of issue. I simply give up because they have their own strong belief. So then the Hummer case goes to the court. The court later on come and say this kind of Baidu's ban the Qihoo's access data is a kind of fair competition. I think that's not a good decision. And the court said, in general, you could use robots to control the content But if you are a leading player, you of course so-called this kind of harm to competition, and then you are forced to open. I don't think that's the decision really makes sense. But it's really very interesting decision whether the first one control the user-generated content. And another one I think is very interesting. Here, the Baidu was the Tsinghua copied Baidu's content. Another case, 大众点评, just like the Yelp, they sue Baidu to provide like Google Map-like service in China. Originally, I think that with these two websites actually don't compete directly. When you want to find a restaurant, you use 大众点评 to find whether the restaurant has a very good rate, something that you will find the rating very high, and then you use the Baidu map to find the restaurant, right? So you use 大众点评 first, and then you use the Baidu map to find the site. So they don't have an interfere with each other's business. Later on, Baidu changed its policy, saying it's not very convenient for the users to find a restaurant. They need to go to 大众点评 first, right? And then you switch to Google, the Baidu map. How about just put all the consumer reviews directly on the Baidu map? So that's become very easy, right? You use the Baidu map to search for restaurant, and then you has all the consumer review directly from the map, right? So originally, Baidu has the difficulty in attracting enough consumers to post their reviews. So they'll switch to the same strategy applied by the competitors. They copied reviews directly from 大众点评, posted in Baidu, and then sued by the Baidu, sued by the 大众点评. And in this case, the Baidu lose their case. So very interesting, right? This case is plaintiff, this kind of defendant. The issue is the same. They copy the content generated by the third party. And Sina.Weibo.com, I think case skip it. It's also very famous big data case. The court also say when the defendants copied meanings of the user's personal information, and the connection of the personal information of the Sina.com is a fruit of labor of the Sina.Weibo, so it should be protected under Article 2. But the defendants violate the terms, and so it's a kind of violation under the anti-competition law. So they treat it as a kind of Article 2 case. For me, I think it's also a problem because the connection of the user's information is put into the Sina.Weibo's server, and was, I think, heavily guarded by their technological measures. So the public does not have access to this kind of database. Only when the defendant has an agreement with Sina, and then you get access through the API. So you could download the information directly from the server, not from the Weibo's every user's web page. So it's you get a direct a shortcut, direct get the information from the server of the Sina.com. So I think this information definitely is a kind of trade secrets, right? So you could apply a trade secret law to protect it. I don't know why the court resort to Article 2 say it's a protection of big data. So, but we don't have a clear rule on that, so we rely on Article 2. I think that it's a mistake. Personally, I'm a friend of the judge of the appellate court, Beijing court. Generally, I talk with her why you treat it as a competition fruit of label issues. She seems to say the party do not raise this issue. They're surprised. Okay, now we move to very quickly the recent legislative efforts on the protection. I also use an example to show you the legislator, even the legislators or decision makers in China do not understand the nature of the issue properly. So they make this kind of mistake. In 2016, the legislator, NPC, come out with the draft general provision of civil law, now already passed in 2007. It's a very important, like a general part of the future Chinese civil code. I think probably this year, right, this March, China will pass the first ever civil law. Yeah, civil code. This kind of general provision will be the general part of this law. In 2016, they proposed Article 1 to 3, say civil subjects enjoy IP rights according to law, and then IP right are the exclusive right of a person on the following object, subject matter. They list all the subject matter. Very interesting. At that time, that's item 8. At that time, 9 item. Item 8 is the data information. In Chinese, 数据信息, not personal information. They have another article talking about personal information. So here, the data information, that means the connection of the data. At that time, the legislature believed. I think that this kind of draft article show to us, they don't understand what's the relationship between data information, connection of data, and copyright words and trade secrets, right? They believe it could be parallel to each other. Actually, it's not. Actually, a lot of data actually contain copyrightable information, right? Sometimes the connection itself work of the compilation, right? So it's hard to say it's completely parallel to the works. And also we know most of the time this kind of data, connection of data, actually is in secret. So probably I guess more than 90% of the data information originally is protected by trade secrets. So if you don't deal the trade secret and this kind of thing properly, how to do this them together? That's the, I think that misunderstanding of the nature of the data very clearly. For me, I think that we should not list them together. Maybe the article saying it's different, right? Later on, the article said they abolished the proposed list, and then we created this article 1 to 7, saying the provision of other status of protection of data. Here, data not personal data. They have another article on personal data. The data means I think here means because at that time no one say it's a big data or big database or connection of data. They simply use the term data. The network 网络虚拟财产 virtual properties. That means maybe in the future we come up with other law to protect this kind of things. I think everything now we start to think about a new legislation on big data. This weekend, I will be invited to a conference organized by PKU Law School and the NPC committee to talk about the legislation on the big data. Probably, I will propose this kind of idea to create a. But I need to find with a lot of this kind of scholar from different areas like civil law or commercial law. They have a completely different understanding of the protection of data. Here, the current situation, I think that in the future, if you want to create a law, how to distinguish this such matter from the existing one, it could be a pretty difficult work. Okay, now we move to very quickly the real narrow legal gap exists in this area. I think now, if you read all the existing case, actually, I think only one type of data deserves this kind of specific legislation. That's the connection data already been put into the public domain, like already available or accessible to the public. And then we need to think about a new regime to protect it, right? For the data, you already, I think most of the time, a lot of people know from Google Map or Baidu or Yelp or Google search engines. This is the data accepted to the public, but it's only among I think the very small part of the data industry, right? Most of data connected by private sector. We never know where it exists, right? So most of them actually under the border. So we don't need any new law to protect that. We use the trade secret, right? Only a small part of the connector, because they have applied this kind of business model they have to disclose some of the information to the public, right? Like Google, Baidu, Yelp, or some other. But this kind of company is very famous, right? But they only among the very small part of the industry. For example, I think the Internet of Things, the operator connect all the data every day, right? Never know where the data exists or stored. So we don't need a new law at all. We simply need to rely on the trade secret law contract. And if you believe the protection is too strong, and then you could impose some kind of legislative restriction, right? Force them to open it up if you think you really deserve it. So only this kind of typical example. In this kind of scenario, maybe I connect the data, but I have to provide the service to the public. So I have to disclose the data. So make it easy for the competitor to copy. So in this kind of scenario, we may create a regime to protect this kind of interest. So that's only in this kind of very narrow area we needed to think about a new legislation. So that's my proposal. So in this area, whether that's a market failure, I think that's also the hardest issue. In China, the Google Map, or 大众点评, YouTube, or Tsinghua, all these kind of connectors actually are a dominant player in this market. A lot of people believe they already become a dominant player, right? Why we need to still reinforce property protection for them, right? They will reinforce the market power. So is a kind of new protection could be against the public policy in this area. So when you propose that kind of protection for this kind of big data, you have to deal with this kind of antitrust issue. Personally, I think we should separate them, because when you think about legislation, you should not assume every connector already enjoys this kind of market power, right? This kind of company actually, when you start this business, they invest heavily. Before they get this kind of market power, they're already subject to the unfair competition or this kind of copy from newcomers. Before they get this kind of dominant position, they already need this kind of protection. Probably upper power maybe. So according to my understanding, only very little, right? If the copyright law require you to, when you cite that data, you need to get a permission from the original creator. It's pretty costly, right? I think the transaction cost could be very high. So it's not worthy under the copyright law to protect the worthy protection of the raw materials. And also the raw materials data is used to express your own point of view. That's the free expression concern is very strong. But why under the big data legislation it could not be a problem? I think that of course we emphasize the protection only available to a huge amount of data, right? So we only stop the competitor from copying substantial amount of data. So it's hard for you to argue, say, as a competitor, you create a derivative work, you need to copy a substantial amount of data from the original, the contributor or the original connector, right? If you cite only a few of a small part of them, that's fine. You can say this kind of freedom should be protected in the copyright law. But if you copy the meanings or entries of this kind of data, you still say I'm creating a derivative work. I think that doesn't make sense, right? It's hard to say you need to copy the whole data to create a derivative one. So I think that means this kind of protection will not cause harm to the public policy maintained by copyright law. And freedom of speech is the same thing. Of course, there are a lot of Tsinghua or other scholars have wrote articles on whether the big data or the connection of a huge amount of data should be viewed as kind of expression. I think that's true. Even a huge amount of data has some value of freedom of expression. but it's hard to say a competitor need to copy 1 gigabyte this kind of data to post or to create a competing expression. That's hard to say, right? So once the size exceeding the threshold, and then the threat to freedom in public domain or the threat to freedom of speech become lower down, and then that means even we provide this kind of protection, it will not cause harm to the public policy and the copyright law. I think that's pretty interesting, right? The small amount of data should put in the public domain, otherwise it will cause too much harm to the public interest. But if the size increase to a huge amount, and then there's no concern on copyright law and constitutional freedom of speech, are very interesting. I think this strike a very perfect balance. So the key element is the size or the volume of the data. Okay, that's that. Now we move to very quickly how to fill the gap. That's two competing point of view. The one say we need to adopt a crocodile-like regime. Another one say rectal regime. Before I publish the article, I have a debate with China, the Japanese scholar Tamura, Professor Tamura from Hokkaido University now, the professor in Kyoto University of Tokyo. I think he's a big fan of the Japanese approach. The Japanese anti-competition law of 2008 adopted an article protecting this kind of big data. Say if you have a connection, a considerable amount of data, if you subject the data to technological measures, and that should be, if the competitor violated a certain way this technological measure, and then it should be treated as a kind of unfair competition law violation. I think they believe this kind of why they support this kind of regulatory regime. We say it's hard to define the scope of big data. So they believe unfair competition law does not need to do so. And then they say only when you subject the data to a technological measure, and then that basically means you already draw a boundary, right, among your data, make the public know where's the boundary, and then we give you some kind of protection. We don't allow anyone to circumvent the technological measure, basically the unfair competition. So they resolve this kind of subject matter problem. But the new challenge or legal issue is, we know that some kind of data should be put in the public domain, right? Even you rely on contract term or technical measure to provide this kind of protection, the court may strike down, say this kind of protection is against the public policy, right? So what's the line? If you don't have a threshold requirement for the size, volume of data, it could be a threat to the copyright policy, right? So I don't think the unfair competition law really strike a better balance than a proper regime system. And the first one is how much data could be protected under the regime. The second one, what kind of technological measure, right? What means an effective one or not? For example, I use robots protocol. Say Google or any other competitor should not access to my data. Could the court treat this kind of technological measure as an effective one? If that's an effective one, the Japanese law could be much more broader than any protection available in this world. It would simply say every data subject to my robots protocol, and then no one could get access, and I could apply this law to protect it. So I think even the article itself, and you read through the text, simply say we put a very narrow protection, only protect this technological measure, and still rely on the definition of what means amount of data, what means eligible amount of data, what means effective or acceptable technological measure. So it could be very broad if you don't have a clear restriction on this kind of issue. So I don't think that really unfair competition means very narrow protection. And also the law, the Japanese law restricts the utilization of this data. That means copy or analyze this data maybe is a violation. I think that under property regime, probably we don't need to protect this kind of interest. In my paper, I argue for only a right to communication to the public. So you cannot stop others from copying your data if you already put it in the public domain. But you could stop them from reposting or retransmitting, redistribute the data to the public. So the rights are very narrow. So I think that's even narrower than the Japanese unfair competition law. So here, some believe that the unfair competition model targets only very specific behavior. They don't create a subject matter and then give you a completely domination over the subject matter, right? That's I think traditional theory, say antitrust law, anti-competitive competition law is completely different from property law. I think that's kind of legal fiction. I don't think that's a really clear line. The part that's true, we say once we create a property rights, we allow you to control the subject matter completely. So it's an absolute control over the subject matter. That's a property. But if you target a specific behavior, it's an unfair competition, not a property. But actually, that's not the current the modern legal theory, especially the realist legal theory, say it's not true. Every kind of right to exclude could be viewed as kind of property rights. But that's depend on whether you still a strong belief in the traditional theory. For example, traditional theory requires you to create a subject matter and then exclude someone from access to the subject matter. It's a property, right? If you could not frame the behavior as exclude someone from accessing to a subject matter, and then you probably believe it's not a property right, for example. And some unfair competition law rules forbidding you from selling goods at a very low price, very high price, right? This kind of restriction is hard to frame as a kind of control over a subject matter, right? So you believe it's not a property right. I think that's probably right? But if the right could be framed restriction or control over a subject matter, even the right is very narrow, it still could be framed as a property protection. I give you an example. We believe the copyright law grant property-like protection to the owners, right? Do you think they really have absolute control over the original work? No. We have a lot of restriction for fair use, right? Defense actually allow the public to use the subject matter without your permission. So it's not an absolute control, right? And also we have a so-called some kind of the expression and ideal dichotomy, right? So we don't protect the abstract idea. All this kind of restrict actually makes the copyright law not like an absolute control of the subject matter, but we still believe this kind of control or the interest is a property-like interest. So here, I think that the big problem for unfair competition law is it looks like narrow, but it is still a big part of how to define the scope, right? Here, we show you the NBA's case. This kind of list is very famous. In the U.S., so far, they don't protect this kind of big data or connection of data as a property-like interest. They only have the very narrow so-called hard news doctrine or misappropriation doctrine. Only when you satisfy on this kind of restriction, and then you get a very, very narrow protection. It's kind of typical competition law regime. Property regime, I think that I propose a very narrow, go very quickly, very narrow property-like protection, only grant the connector the right to include the communication to the public, no other rights. So it's much narrower than a typical copyright, and also much narrower than the European directives, so-called sui generis rights. I think the EU legislation is too broad. So very narrow. I think this kind of understanding could resolve most of almost every case we heard in China and in this world. For example, all the case we mentioned is about the competitors copy the data and then transmit it to the public again, right? We make it available to the public again, directly compete with the original one. So if you have this narrow right to communication to the public, you could stop that. And for example, another case is a very famous US case, LinkedIn versus HiQ. The HiQ used LinkedIn's data, and then I think they create some kind of derivative result, right, and then repost to their consumers. But they don't directly transmit make available the original LinkedIn data to the public, right? So this kind of derivative use should be allowed if we only create right of communication to the public. So that's why I think that's this kind of legislation should work. Here, I think the Y profit regime is better than regular one. I think first, I think when the data or big data become more valuable, I think the inevitable tendencies we will make it as a property subject matter. A very famous article. I think that's just like I think that this article is probably as important as the Donald Coates, the social cost article. But I don't know why Professor Demsess did not get the Nobel Prize for this kind of paper. This person said when the value increased and then the society could tolerate more this kind of administrative transaction cost to install a proper regime. I think big data is the same thing, right? The value becomes more valuable, could create a better narrow. Even the administrative cost is pretty high, but if the value is much higher, it's still worth it to do so. So I think that's the inevitable tendency. And proposed, I think the regime property one is very good for the business sector because you could follow existing tradition set forth by property law, right? How to transfer it, and if you frame it as an unfair competition law, it's hard to formulate to set up a kind of intermediary market, right? You buy a right from the connect of data, and then what's the nature of data? It's the right to avoid unfair competition. It's hard to frame the downstream transaction, right? You could create the property-like one. You could simply fit into the existing property regime and make the whole market develop very fluently. That's why we think the property regime is better. And also, because I think that the current system, like the copyright regime, already being administered by the copyright office. If you frame it as a property one, and possible for you to put into the copyright law in the future. And this kind of copyright office is pretty familiar with this kind of issue. So it's better for the legislature to allow them to manage this kind of affairs rather than allow the unfair competition authority to do this. I think they are not familiar with the basic principle of copyright law. So there's a lot of different policy concerns. Whether the property regime will overprotect, I think not necessarily. That depends how to define the scope of the subject matter, how to define the content of the rights, right? You could define the scope very narrowly. For example, you require a substantial amount of investment plus substantial amount of data. I think the European law does not require. The EU, I think the big problem for the EU law is they have no direct requirement for substantial amount of data. So that's the problem. Some scholars even believe you create a web page, contain some information, this kind of web page enough. It itself could be a database and the EU directive. I think that's ridiculous. The investment is very low and the amount of data is very small. So that should not satisfy the basic requirements. And you could limit the instance of right only to the right of communication to the public. So very narrow. The EU a very broad one. So even you create a regime, proper regime could define very narrow. And you could also apply a lot of restrictions, right? So for example, like term arbitration, protection, only 3 or 5 years. That depends, right? I think the internet industry may only need 1, 2, 3 years. And the pharmaceutical industry or other traditional industry may need more years, for example, 10 years, something. But you could strike a balance, 3 to 5 years, something like that. And also have, you will create something, exception like fair use defense, and also another very interesting one, data portability exception. That means whether I mentioned at the beginning the Tsinghua.com case, and competitor want to move all the celebrities' posts to their own website. Whether the netcomer could get the permission from the celebrity and then automatically move all their posts to the newcomer website, that's a very big issue. Someone believes it should not, because Tsinghua.com originally connect all the celebrity posts, right? It's a substantial investment of money, so you should protect Tsinghua.com interests. But the netcomer say, I already get the permission from all the celebrities, right? They authorize me to move all the content from Tsinghua to the second website, the dependent website. That means if you read the GDPR, the EU Personal Data Protection Law, you say everyone should have the right to freely move the data from one website to another website, right? Here you see there's a conflict, right? Every user has the freedom to move that data. So if the netcomer got the authorization from all the users, and then they could move substantial amount of data from the first one to the second one, right? You move only 1 or 2, that's fine, no problem. But you move all the celebrity or substantial amount of the celebrities' data altogether to the netcomer, whether you need to get the permission from the original website. I think that's a big issue. Case pending in Chinese court. Personally, I prefer to create an exception. Say, if you really get the permission, every celebrities or user permission, then that should allow you to move all the data to the second one. Someone may say this kind of exception could become a threat to the first one interest. But you need to do a balance, right? If the second newcomer really attract enough celebrity and get all the permission, that must means the newcomer already become very competitive, right? They have provide very good service. That's why the celebrity want to grant the permission, right? If they already got the permission, that means they don't rely really only on the data itself, right? They already enjoy some kind of competitiveness in the market. So maybe it's better to create an exception. I don't know. Itself deserves a separate paper, right? Whether the joint rights of the user should override the connector's interests. I don't know. This could be also other exception. So the system could be very complicated. A basic probably line, very narrow protection, and subject to a lot of restriction.
The case is pending?
Yeah, it's still pending. I think that's a very important one. We probably, I don't know. Originally, I support the Tsinghua.com saying should protect your interests and investment. Later on, I realized maybe user interests are also pretty important, right? Maybe if you already got this permission, I guess we should create exception. Okay, Joe, I think that we spent too much time, so we see all these kind of issues. If you are interested, I don't know, we can deal with the Q&A comments. Okay, thank you.
Thank you very much. Apparently, Guobin is not like too many questions. you only leave us for like 30 minutes, less than 30 minutes. So because I've been in Tsinghua in December, I was dragged by Guobin into discussion about this big data thing, so I won't spend much time asking questions because I have already asked a lot. So I will leave the floor to all of you. So anyone have any questions for Guobin?
I'm not an expert in the field, so you'll apologize if this is a very simple question. When we were, in my past life, I was a scientist, And
Okay.
we have a similar problem in the sense that different countries collect data. And sometimes they're prepared to share, sometimes they're not prepared to share. One of the criteria is whether they are used for profit or not. And in one of your slides, there is the test of whether it has commercial value.
Mm-hmm.
So the question is, if the reproduction of the data set is not done for profit,
Mhm.
but is done by an NGO for the purpose of informing consumers or something else, do you think that the resolution or the treatment of the data should be different?
Okay. I think they're very good questions. And in the US, when we talk about the US in 1990, they also have some efforts to create I think the EU directive on like the protection for database. A lot of people oppose the legislation. They say this kind of protection could be a threat to the free exchange of information among the scientific community, science community. They say, in the past, this kind of community has a traditional share this kind of research result, right? Now you give them a new idea, say you could treat this kind of profit-like things, it will discourage this kind of sharing of data among this kind of community. It will become a barrier of progress of science in the future. Personally, I think that's true. If you already capture the content, not for profit purpose, right, make it available to the public, it seems that you don't need any protection at all, right? But here, I think even we create a property regime, that does not mean we will stop this kind of sharing. You still could, for example, when you publish this kind of data, you post a notice here, say it's freely available to everyone, right? Just like now you rely on GPL or CC license terms to allow everyone to free. I don't know whether you know this kind of the open source movement. So you could freely choose to rely on the property regime and license it out through this kind of contract term, allow everyone to use. So that's no conflict. If the value is high enough, I think that you have the incentive to encourage others to freely use it, right? So even there's a regime protect this kind of non-for-profit database, it's still easy for you to distribute, allow the downstream user to use the data.
Okay, is that satisfies your question?
Yeah.
Okay, so Jian first, and then Chen.
Yeah, I think Guobin makes the right point. The issue today, which is very different from probably just 10 or 20 years ago, is that the data is big.
Yes.
And for this kind of protection, the new regime, of course, as Guobin said, so a key issue is how to determine what is big enough to constitute appropriate protection. But if you think more about the detail, for example, just take one, term of protection. So the data that we are having today, so is somehow different from the past, which is that the data is generated every day. So sometimes it's not very easy to find like the right set of data, the scope of the data.
Yeah.
Because it's actually dynamic, it's flowing, it's not like the fixed amount of data. So sometimes not that easy to define the scope. And then when we talk about the terms of protection, then it's not that easy to say, hey, the data is generated probably, the data we have now is very different from the data we have an hour ago. So that might create some problem, as I see.
Yeah, I think that the very big problem actually, the main reason for a supporter of the regulatory regime, they use the kind of the reason to fight against the private-like proposal. They say, how could you define the scope of the data that they evolve every day, right? I think the problem is even under the regulatory regime, unfair competition regime, you still have the problem, right? Your the whole website, you post a lot of content there. You means I could not copy every content of the website. You must determine how much I could copy, right? How much I could not. How to resolve to draw the line between permissible or impermissible. That's still a problem. For me, I think that the data is, I think that the diversified in different areas. For example, in the traditional, in the hospital, they connect a lot of patients' data. That data set does not evolve that quickly, right? You know, one patient have the set of data, another millions of them. I think the boundary is pretty clear. But in internet, for example, on the e-commerce area or the Internet of Things, and they connect that every day, right? But the problem is, I think we don't need to define the scope of predictable data in advance. We only look at the amount of data you copy, right? And then we could look at how much data you copied within the term of protection, right? That kind of data must be identified by the plaintiff. Otherwise, you could not sue, right? You might figure out how much data you are copying, and then I think in the digital age, it's easy to figure out almost every entry of data is starting point, right? You know this data is posted by users. For example, we are cutting date, say 2 years ago, right? If you start from that, and then all the data within this period is protectable, and then you could identify all of them. I think in this area is not a big problem. Even in the traditional law, for example, the gas or the flowing water, right? Whether it should be viewed as a subject matter of property, you have the same problem, right? It's hard for you to define the scope of the subject matter. Here, the same. I think I agree that a big problem we need. For me, I try to. Actually, I wrote 2 articles. One published, one another is. I'm waiting for someone to. The first one to just give you some basic theory why this kind of protection is justifiable, and what kind of model we should choose. And the second article we talk about how to define substantial investment. For example, investment for creating every entry of the data should not be counted. For example, you create a video like you post in YouTube. Sometimes an entry is a kind of a film, right? It costs millions of dollars, but this does not matter. I think for the collectors, that means nothing. We only care about the connection of the existing data. We don't care about the investment in the creating a specific data entry. Why? This kind of investment in a specific data entry already being covered by existing copyright law or trade secret law, right? Because you invest millions of dollars creating this video, or you invest millions of dollars creating a trade secrets formula. This kind of formula itself already covers trade secret. We don't care this kind of investment. That's the mission of the trade secret law, existing IP law. Now we only care about you put all this entry, just like in my article, we call them black port. You claim a lot of different black ports together, and then we care about this kind of investment. So we need to care what it means in substantial investment and how to define substantial amount of data, right? In the past, we don't know why we need a substantial amount, but under my survey say we want to distinguish your protection from the copyright law's policy, right? Copyright law say a small amount of data has a public policy concern, right? So you must define the amount of data in a way to avoid any interference with public policy. So they give you a guidance how much data you need. Usually you should be more than 10 or even more times than the size of the typical copyright work, right? To draw a clear line between copyright policy and this kind of new protection. So that's a pretty. I think that the term is another issue. How to define the term is a lot of challenge. Maybe we still believe big data is not that valuable. We don't deserve this kind of this kind of very complicated copyright property system is still not desirable. Maybe we need to still wait, right, until the data have much more value, and then we think the legal certainty become more important, and then we will adopt a profit regime. I think this will also depend on the value of this kind of resource. It's developing every day, and even today we think the very narrow protection enough. Maybe in the future the value will become more and more higher, and it will be more valuable. And then you probably say we need to give more incentive for someone to connect this one, right? And then you probably will broaden the protection. Same way, how about give you a right of reproduction? and to generate more data in the future. It's still possible. It's theoretical. That's possible.
So, okay. Thanks for your presentation, which is very informative. I have two quick questions for you. The first one is you are proposing a new copyright line, exclusive right on big data.
Yes.
And especially for non-personal big data, right? Yeah. So
Also including personal data.
okay.
We don't care about the nature of the every entry of the data. We don't care. We only care about the connection of the data entries.
Okay.
It could be a personal data, could be a copyright work, could be a image and civil law, something like that. That doesn't matter. It's just like a black spot.
Okay, so some scholars also argue that of course we should provide some legal protection for big data, but not through an exclusive right, but access to big data. And so the key difference between those scholars and your theory is that whether market failure really exists in the current big data industry. And in one of your slides, you also mentioned that there's current market failure in this regard. So, but to my knowledge, even after those data disputes happened in China, there's a current data industry is still on the rise, and there are even some newcomers to this industry. They also choose their business model. They publicize their big data, right? So my question is, it is market failure there? I mean, market failure. I mean, is there some under-investment in this either data industry?
Yeah, I think the very good question is an empirical issue, whether really we have a market failure, right? I admit that in my case, the weakest point of my paper, you need to do a very complicated empirical study to show this area we really have under-investment, right? It's very difficult. I think that's probably need more time than writing this article. My purpose, I simply want to provide a theoretical framework for thinking of this kind of an issue. And then in the future, we could do further research to confirm, probably to prove every point of the proposal. It's hard. And whether does it really have market failure, I think it's very interesting. If you read the articles wrote by mainstream scholars in each world in the 1990s, when they talk about the need of necessity of database protection, like Pamela Samuelson or quite a lot of scholars, it seems to them that there's no dispute. Of course, there's a market failure. The only dispute is how to resolve the problem. Either a relatively narrow hot news doctrine, or we create a relatively broad sui generis protection, like the EU one. At that time, they use a typical example like Westlaw's database. If I connect all the cases, all the law journal articles together and put online, and then if you allow the computer to freely download and then we communicate to the public, that's definitely no one will have incentive to create the original database, right? For them, I think this is a persuasive example. In China, you mentioned Sina.com or the Google or the Baidu Map case, whether like Baidu one, I have a debate with the panel I just mentioned. They believe Baidu already become a leading player. They have abused the position and make a lot of people not happy. So now the newcomer is the Tsinghua 360. Even they could, I think could get a cut off 10% or 20% of their market share. They think it will not become really a threat or really going to kill the bank, but it still could compete effective with the newcomer. The problem is still how much value they got from this kind of competition. The 360 could easily, just in several weeks, get 10% or 5% of market share. How much money that share worth? It said at that time, say 1% probably means more than 10. At that time, I think 100 million renminbi. So if you allow the second one, could easily cut out the 1 to 10% of the dominators' market share for nothing, right? I think that's simply unfair, right? And that basically means that you can say that the first runners still have the incentive to compete, right? But I think that does not mean that competition is at the optimal level, right? If you know the second one could easily cut out at that time they believe to have 10 billion renminbi easily. If you allow this one, you say 10 billion still could not kill Baidu, right? I think they simply put this area as you should not kill them, but you still can get a very significant free ride. I think that's the problem. If you think about some market at the beginning, there's no dominant player, and then everyone could freely copy each other. I think that's the nightmare.
Okay, my second question. So you listed some restrictions to the property like right? But I didn't see a compulsory license. So what if, according to your theory, what if the right holders they hold up their data as you don't choose to license us to use? So in this sense, I mean, is compulsory license possible to be a kind of restriction to the?
Sure. Here, I think that public health or public security or other interests, public interests, could be an excuse for you to create this kind of compulsory license. I think that's already become practice, right? Even under the existing trade secret law, we already created a lot of regulation, actually deprive it of the holders this kind of rights. So I think that could happen in the future, the same protection for big data. That's definitely true. But in this area, that has very interesting research saying whether really we could easily label someone as a dominant player, hold up the whole industry. I invited the professor Crystal Yu from UPLANT to give a lecture at Tsinghua. I think he's also a titled lecture about his draft paper, whether we could easily treat big data as a kind of central facility for competition. His answer probably no. A lot of people say the size of data is very important, so you believe to compete you must have that size of data as an original connector. But actually not. For example, if you want to predict the market tendency, you need to have a whole bunch of data like Alibaba owns. Actually, you don't need it. You could do some kind of market investigation and a poll and among a small amount of user, and then got the tendency probably not that accurate as the Alibaba, but probably get 99% or 95%. That's enough in many cases. So their research shows that we should not easily label owner of some kind of data as a dominant player, hold up in whole industry. I think the same thing, for example, you often use the in this case. Baidu, in their part, they say they need to copy directly In's consumers' reviews to gain this kind of competitiveness in the market. But actually, later on, they find another resource. You don't need to rely on the consumer reviews at all. Because as a good Baidu map, they provide this kind of guiding service to many users. You simply look at how many users chose a restaurant as the destination for this kind of map service, right? If you find this restaurant among the first top one, probably this kind of restaurant is most popular one in Harbor City, right? And then you don't need to read the reviews at all. You simply rely on the consumers, the data, the choice of frequency, and then tell the people which one is the most popular one, right? So that means it's pretty easy for you to find another way to compete with the holder of the big data. So I think it's very interesting. It's also a very interesting topic to worthy research, further research in the future.
Okay, thank you.
Okay, we still got time for one last question. Okay.
So thank you very much, and thank you for a very inspiring presentation. So actually, before listening to your presentation, I'm very hostile to properties in data, and your presentation sort of convinced me that at least we should offer certain protection. Maybe we should propertize a little bit of those big data. My question is, how shall we define the substantial investment? Because it is relevant to my another question. So whether we should propertize the raw data, such as those data directly provided by users and without any further process done by the collectors.
Yeah.
So whether those data should be protected, because someone believe, okay, we should keep this big data market open.
Yeah.
And for those raw materials or raw data, we should sort of they are free. They should be put into the public domain.
Yeah.
They should be freely accessible to everyone.
Yeah, I think that's a very important question. That you will read this kind of data protection law journal articles, scholars doing research, how to make sure this kind of scientific data is freely available to the public. They emphasize the importance of this kind of sharing, as I just mentioned. For me, I think how to deal with this issue first, we must define the substantial investment very narrowly. Say, the user, when creating the kind of raw data, the investment does not be counted at all. For example, if you the real case happened in, I think very interesting, in European Union, the legislation does not talk about what means a substantial investment. And later on, their judicial courts and the ECJ have to deal with a lot of cases, especially they gradually narrow the scope of investment, say only when the connection, the arrangement of the data will become the original investment in finding or creating the raw data is not be viewed as an investment under this law. Why? I think that, for example, if you do to test the quality of the soil, right? You do a very complicated scientific testament in the test in every area, and then connect a lot of this kind of raw data. This kind of data costs a lot of investment, probably hundreds of millions of dollars. But when you finish this kind of test, this kind of data should be subject to the protection of trade secrets law, right? If you chose to put it into the public domain, I think that if the amount of the data is not substantial, or the connection or the arrangement of the data is not substantial, we don't need to give you extra protection. You chose to put it in the public domain, that means you already believe this kind of use is in your best interest, right? So I think that it's important to draw a line between the investment in connecting or the arrangement of the data and the investment in creating the data entries. In some cases, could be very, I think that the line is not very clear, but in most of cases, still we could find a workable standard. That's my understanding. Later on, we can talk about it.
Okay, thank you very much. I think we have a fruitful discussion today, and let's come together and give a big applause to Professor Sui for his great talk. Thank you very much. Concludes our event today. So in the afternoon, we also got an IB seminar. So if you're interested, then all of you are welcome to join as well. Thank you very much.
Okay, thank you.
And this is a gift from us.
Take a picture. Okay.
1, 2, 3. So. 1, 2, 3. Okay.
Okay,
thank you.
Thank you very much. Thank you.
I'm not coming. Yeah.
Thank you very much. 食飯幾樓啊？